Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of CLR, Bruce Rivers Criminal Lawyer Reacts. I'm a board-certified criminal defense lawyer. I have 23 years of experience in trial cases to a jury, and today we are reacting to, as you scroll through Instagram and Twitter and all that kind of stuff, we come across stuff just like you do from time to time. And this is the double murder suspect defending himself, screams the opening statement at the jury. Now, this is a pro se defendant. Now, what's a pro se? What does pro se mean? That means you're pro se means you're doing this on your own. It means without a lawyer. And so when you're a pro se, just because you're not a lawyer doesn't mean that you're not held to the same standards as a lawyer. But today we're going to talk a little bit about opening statements. So when you have a trial, there's a whole procedure that you go through. But to start off with, the prosecutor goes first and gives their opening statement. And in the opening statement, you tell the jury what you think the evidence is going to show. And it's not supposed to be argument. You're supposed to just give the foreshadowing of what the trial is going to be about. Ladies and gentlemen of the jury, thank you for your time and attention. This case is about X, whatever X happens to be. The evidence is going to show that in this case, Mr. Dickhead decided to pull out a firearm and shot it, whatever, however that goes. And so it's your, give the jury what to expect. Now, it's never a good idea to be your own lawyer. I'm just going to tell you right now, it's just never a good idea. So, without further ado, let's get into this and let's see what this guy's opening statement is all about. Right off the bat, he's very theatrical. And he looks good. He's got a nice tie on. He's got a very creative hairdo. And he's a very serious individual.
The evidence is going to show that we are under some of the most vicious
Now, if you are giving an opening statement, started out okay in the sense that he said the evidence is going to show, but that's where the evidence or the talent here kind of ends. He is extremely agitated, to say the least. Now, this guy's on the hook for a double murder. And if you didn't think he was angry, or, sometimes your argument has to be impassioned, sometimes it's not impassioned. But when you're the defendant and you're giving an opening statement, you don't want the jury to think, oh, I could see this guy killing a couple people. And if you look at him, he's just mugging the jury.
Our time is all said and done. You will see who is the mass murderer.
So now, I know I'm stopping this a lot, so I will keep going a little bit. But here's the thing. This guy is on the hook for a double homicide. He's extremely agitated. What you don't see in this video are the deputies, because I guarantee you those deputies are nervous, anticipating something crazy is going to happen. I don't think it does, but because he's not in handcuffs. In any other court appearance, he's probably in handcuffs. But when you are a defendant in a case like this, you can't be in prison scrubs in front of a jury. That's your constitutional right to be viewed as a normal citizen. That's why he's got street clothes on, even though he's probably in custody.
You will know why what occurred on March 18, 2018 occurred. And the evidence is going to show that law enforcement tampered with evidence to meet their such high burden of proof. Because originally, it wasn't enough.
So now this is actually not bad. You take away the anger. I mean, because he looks like he's just really fucking pissed off, and he looks like he wants to kill somebody, probably the state of Florida. But he's got a theme going here. That's one of the things that you do in an opening statement. You develop a theme, and his theme is they tried to charge me before, it wasn't enough, so they fabricated evidence, and the police is fabricating evidence. It's a good theme.
So we had to tamper with evidence. Since it was such evidence already, but we still had to tamper with evidence.
One of the issues with that, though, is if you promise something in an opening statement, the trial better deliver. Otherwise, you lose a lot of credibility.
Evidence is going to show my son did not see me murder his mom. The evidence is going to show he did not see me shoot his mom. The evidence is going to show my son said many things that are not true.
And one of the things that you do in an opening statement is that you talk about the witnesses, you talk about the evidence, and that's what he's talking about here. So from that standpoint, I don't know much about the case that he's talking about, but he's doing kind of what he needs to do here.
The evidence is going to show that I called 911 during Kenyatta Barron's 911 call.
Here's the other thing. Now, as a defendant, you have the absolute right to remain silent. So the government can't make you testify. And guess what? If you, and this is genius for some people because I've seen this actually work. When you are a defendant, you can agree to not take the stand, but you can give an opening and a closing argument and basically testify, and you're not subject to cross-examination. So that's only when you're representing yourself. So it's kind of a trick, really.
But all of a sudden, it ends up after I called Kenyatta, after Kenyatta Barron's call was made. Now I'm calling 911. But originally, I called 911 without even knowing she called 911 during her call. But the evidence is going to show that your representatives and law enforcement, local law enforcement, wanted to make it seem like I'm some kind of menace to society. And I ran after killing Kenyatta Barron, knowing that authority was on the way to kill my own children. I wonder why I would do something like that.
Now that's argument. You can't use argument.
For no reason. I'm standing here competent as can be, representing myself today.
I guarantee you somebody told him what an opening statement is supposed to be. And here's the other thing, because he keeps using the evidence is going to show, the evidence is going to show. And in all likelihood, even though he's representing himself, the court probably has standby counsel to advise him. And so there's probably a lawyer, public defender or somebody that's standing by, that's advising him from time to time.
My son did not witness me viciously beat his mom to death. The evidence is going to show my neighbor, Khalil Brown, whom they are trying to keep out of this trial, witnessed me take 3 strikes. The evidence is going to show that law enforcement and this administration wanted to make me look like a menace to society. So they added several mini stripes on that video and audio that you just heard. And
when he's talking about the audio and video that you just heard, he's probably talking about something that the government played in their opening statement. And generally speaking, you're not supposed to play evidence because it's not admitted as evidence yet. It's got to go through the process. So, but he's in the opening statement, they probably played the 911 or they played some audio video.
added several statements that I did not say. Anything that I may have said, they exacerbated it and made me say it consecutively over and over like Allahu Akbar, which I may have said once or twice, but they wanted to make me seem like a terrorist, and so you hear 8 or 9 times, and you hear me calling Kenyatta Barron a bitch and a whore. The evidence is going to show that I called my dad after calling 911. But that call is all of a sudden missing from the T-Mobile records that we have acquired from T-Mobile.
So in order for anybody, he's talking about phone records all of a sudden just magically missing from T-Mobile. It's a far stretch to have the cops doctor evidence like that. I mean, they just don't do it. And they get the records directly from T-Mobile.
The 911 call that I made to 911 and the 911 call that you just heard cannot be proven that it was made because after I called for an investigation of those 911 calls, all of a sudden they become missing from all evidence.
There's no way that if he calls 911 that it would be missing, because they would use that against him as consciousness of guilt. I guarantee it.
The evidence is going to show Kenyatta Barron supposedly made a 911 call, but you cannot find that on her call log, which we pulled from her actual phone. They say she made a call at 11:43. There's no 911 call at 11:43 on her call log. All of a sudden, after I called for an investigation of the original call, That's what the evidence is going to show. The evidence is going to show. I look alone, but I am backed by a mighty God.
Invoking religion never helps you in an opening statement. In fact, it's objectionable, but they're letting him go because they know that he's not being effective.
The evidence is going to show I love my children. And the evidence is going to prove to you that this whole entire case has been tampered with and fabricated.
The evidence is going to show that this whole entire case has been tampered with and fabricated. Here's the thing. If you promise something in an opening statement and then it doesn't come to fruition, you're going to lose your case because they're not going to believe anything you said, and you lose the benefit of the doubt. Give an example. I had a case where my client was telling me, I was trying to put forth the belief that the cops had planted a bullet in my client's pocket. My client was on the hook for murder one. He was alleged to have killed his ex-wife's lover, okay? And he gets picked up the next morning after the guy dies at a gas station, and he gets picked up by the Violent Offender Task Force, the VCAT team. And so they arrest him and search him, put him in the back of the squad car. Don't find anything on him. They bring him over to the homicide unit where they interview him. After they take him out of the car, search him again, put him into the interview room, and they interview him. And they get done with the interview. They bring him and they put him in the car, and then they bring him over to the jail. So now he's been searched 3 times, right? He gets over to the jail. They do an inventory of everything you have on you. They take his pants off. Oh, and look what they find in his pocket. They find a bullet in his pocket. Well, guess what? Halfway through the trial, I get a CD from the cop, or from the prosecutor, and it's he's talking to his cousin. Of course I knew the bullet was there. I was just being a smart ass. Because once they found that bullet, they went back and talked to him, and he said, I don't know anything about no bullet. And then turns out he did. He was just being a smartass. So the bullet was there the whole time. So when I went down that primrose path, and then my client gets busted on the telephone, I lost credibility.
I can guarantee you that. Mark my words. The evidence is going to show that they say, I said, come out here, son, and help me kill this bitch. But my neighbor, Khalil Brown, nor my neighbor, Mona Lisa brother, Greg, or any of her children, Mia Thompson, or Reggie Diggs, or Mr. Gray, heard me say any of those things.
See, an opening statement really shouldn't be that long. It should be about 15 minutes tops. And then my closing arguments usually are about a half hour or so, depending upon how complex the case, how long the case is. The juries know what you're getting at. I had one in a murder case. I had a prosecutor give an hour and a half closing argument, and one of the biggest complaints afterwards, because I talked to the jury sometimes afterwards, they thought it went on and on and on and on. You make your point, you get home.
In fact, the evidence is going to show that Khalil Brown heard me say, she killed me twice and then knocked me out.
Ostensibly because she's dead.
CRA is going after all. The evidence will show that in that CRA, I told the neighbor, don't come outside, call 911 now. But you don't hear that on this audio for some reason. But you hear all these other things that I did not say.
See, here he's arguing, and that's objectionable. But the prosecutor's not objecting because he's letting him just dig himself a hole.
The statements of Khalil Brown saying that he saw me take 3 strikes with that shotgun and nothing else. The evidence is going to show that Mr. Harmon here says that that big chunk missing out of her arm was a bird shot. It was not a bird shot. And whatever kind of shot it was, if it was a slug shot or a bird shot, where's the missing pieces of her arm?
With the missing pieces of her arm.
You will not see any missing pieces of her arm in that.
So, this was just a few snippets of this case where somebody's representing themselves on a very serious homicide, double homicide, trying to be almost a triple homicide. And thank God the little boy is alive, but the little boy is, I'm sure, going to have PTSD for the rest of his life from what he saw. When you have a and courts generally don't like it when people represent themselves because it just doesn't go smoothly. But you're absolutely entitled to represent yourself, but you're held to the same standard as another lawyer. And doing the opening statement like this, so angry and so out there, all you're doing is you're showing the anger and the rage that was a portion of what happened that particular night. So I don't know any rational person who would think that would be an effective argument strategy. Be that as it may, that's what an opening statement's all about. An opening statement is you start with a theme, you go to the introduction, you get your theme, you're the body, and then you could come back to what you said at the beginning. Basically, it's like writing an essay, but giving the jury it's like an essay, giving the jury kind of a foretelling of what you believe the evidence to be. So these are just, I thought it was very interesting and comical. If it didn't involve a double homicide, it would be more comical. But it's really sad that somebody died the way they did. So anyway, this is Bruce Rivers, Criminal Lawyer Reacts, and we were reacting to a pro se defendant, that's somebody without a lawyer, doing his own opening statement in a double murder case. So if you're watching this, you should follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time.